Hi everyone, welcome to our talk. I'm Mang Cai, attorney at New Weiming Law Group. So the topic for this video is when should you get married from an immigration perspective? Well, we know US citizens actually love to marry foreigners. So one of the largest section of all the incoming immigrants to the US each year, they are immediate relatives of US citizens. And besides that, there are also other family-based immigrants like spouse of US permanent residents or green card holders. So for example, if you are going to marry someone who has US green card, well, that person can also apply green card for you. And in addition, if your current or future spouse is applying US green card through employment-based immigration, he or she can also help you get US green card at around the same time schedule. So specifically, for example, if you get married to someone who's currently applying employment-based immigration in the US, either employer-sponsored PERM application or a self-petition of EB-1A or NIW, as long as you get married before the I-485 approval, in other words, before the main applicant who filed I-140 received the green card. If you get married before that, you will be considered the derivative beneficiary, and you can immediately file the 485 together with the main applicant to get your own green card. So if you get married before I-485 adjustment of status application is filed, well, the two of you can file the I-485 together, one as the direct beneficiary, the other as the derivative beneficiary. What if the direct beneficiary's I-485 has already been filed, but is still pending, not approved yet? Well, if you get married at that time, before the I-485 approval, you can file your own I-485 on a so-called follow-to-join basis, based on the direct beneficiary's previously approved immigration petition, such as I-140, and file your own I-485. And in this way, you can still expect to receive your green card around the same time with your spouse. So that is employment-based green card. And what if, when you get married, the other person already has US green card? Well, in this case, he or she can file family-based green card application for you by file the I-130 application. In this case, the green card holder will be the petitioner, and you will be the beneficiary of the I-130. And for this type of application, there will be some wait time, for the quota visa number to be available. You can check our other videos discussing about the cutoff date and the priority date of family-based immigration for this. What if you marry a US citizen? Well, in this case, there will be two major benefits. Okay? One is there's no waiting time. The US citizen can file I-130 for you, and in the meantime, you can file I-485. There's no quota limit, so there's also no waiting time for visa number because there's no specific numerical limit on the visa number. So in this way, you can get your green card faster. And also, if you enter the US legally, as long as you enter the US with the inspection at the border, even if your current immigration status already expired, for example, you came as a student and later your F1 status expired and you do not have other visa status, that's okay, as long as you marry a US citizen and your spouse can file green card application for you and the gap is not a problem. Finally, well, if you already have a child and you get married to a US citizen, when you get married, if your child is younger than 18-year-old, well, that child can also get the green card around the same time with you as a derivative beneficiary. If the child is already 18 at the time you get married to a US citizen, well, it will take longer time for the child to receive the green card, but it's still doable. And what if your loved one is abroad? For example, if you are a US citizen and you want to marry someone who currently lives abroad, okay? Or if you are currently outside of the US and going to marry a US citizen, well, there are two ways. One is you can get married and after the I-130 approval, you can apply the immigrant visa abroad. And another way can help you get together faster. That is the so-called K visa. So the US citizen can help the fiancé abroad to apply the K visa. To do that, US citizen needs to first file the I-129F form to the US CIS to prove you two already have known each other for some time, proof of relationship with supporting materials. After the approval of this I-129F form, the fiancé abroad can apply the K visa to come to the US to get married. Well, after arrival, the marriage needs to be held within several months. If the marriage is not held, the K visa will become invalid. As you know, recently there's more strict rules by the USCIS, and the applicant's past immigration history is always examined before the green card is approved. In addition, as you know, these days before the approval of green card, either through the I-485 inside the US or immigrant visa abroad, there will be an interview held. And of course, one focus will be the bona fide, the good faith marriage relationship. So you need to demonstrate the existence of the good faith marriage relationship supported by evidence. And that's all for this video regarding when should you get married from immigration perspective and how the benefit will follow. So if you have additional questions, you can contact us. Thank you.